This is one. All right. Can everyone see the presentation okay?
Yes.
Okay, perfect. All right. Well, thank you again for inviting the Office for Dispute Resolution to your meeting. My name is Anna Cook. Again, I'll be providing an overview of the services that ODR offers. We do have a lot of information to cover, so please ask questions as we go through the services, but if you have a specific question that involves confidential or protected information, please hold that question and we can either follow up or we can talk more at the end, just so we can get through everything. All right, so the Individuals with Disabilities Education Act mandates that each state provide due process and mediation options for parents and local education agencies, schools, to resolve special education disputes. The Commonwealth of Pennsylvania fulfills this federal requirement through a contract with the Office for Dispute Resolution. While we are funded by the Department of Education, we operate separately and independently from PDE. ODR administers both the due process and mediation in Pennsylvania, as well as additional non-mandated dispute resolution services as well. And we're going to talk about all of those. So the way that we operate is the ODR Stakeholder Council is comprised of a diverse group of stakeholders from the special education community, including parents, advocates, attorneys, educators, and others. This council provides valuable input to our ODR director regarding ODR services, and more importantly, members of the Stakeholder Council participate in interviewing candidates for hearing officer positions when they become available and recommend those candidates for hire. Our mandated services, again, are under state and federal law. A due process hearing is required, while mediation is also mandated but remains voluntary, meaning both parties must agree to participate. In addition to these, ODR offers several early and local dispute resolution options that can be utilized instead of or alongside of due process and mediation. These options include special education consult line, where if you call, you'll actually speak to me and eventually you'll speak to Beth and one other consult line specialist as well. IEP and IFSP facilitation, resolution meeting facilitation, creating agreement training, and hearing officer settlement conferences. We will explore each of the options later in the presentation. So this is our dispute resolution continuum, showcasing all of the options available for resolving a dispute. So to the left, we have the more informal, interest-based options. And then obviously to the right, we get more formal and they're more rights-based. Does anyone have any questions on these so far? All right, wonderful. Well, we'll jump right in. So ODR has been recognized by Cadre and OSAP as an exemplar in special education dispute resolution. So that's pretty great. Particularly Pennsylvania, which is very interesting because Pennsylvania is a pretty litigious state. And they were comparing us to Midwestern states that really don't get many due process cases. So the fact that we were recognized is wonderful. So first, we'll talk about the special education consult line, which is my favorite part of ODR. The Special Education Consult Line is a toll-free resource for parents and advocates with questions or concerns about special education-related issues. Each year, Consult Line assists approximately 3,000 parents and advocates of children with disabilities, and the specialist will provide information about the state complaint process, clarify the law, outline parents' rights, and explain the procedural safeguards. It's important to note that while we are not advocates and we're not able to give specific advice, we offer information and options. Specialists can also refer callers to a comprehensive library of resources to further assist parents and advocates. There are numerous alternatives to filing for due process or a state complaint, and we provide information about those options. Sometimes we have to ask clarifying questions, such as, have you addressed your concerns with school administrators? Have you called an IEP meeting to resolve those issues? What about mediation or IEP facilitation? While specialists will explain due process and the state complaint process if it's relevant, since these are very important rights, we also emphasize exploring other options first. Because we can't act as advocates, we can't advise on what steps you should take. However, it's our duty to ensure that parents are informed about all of your options. We also provide some information for early intervention families and advocates, but often we have to redirect you to OCDEL for inquiries about early intervention related matters. whereas we cover more of that mediation due process for early intervention. OCTEL also offers a similar hotline to Consult Line. And again, we'll provide that facilitation, mediation, due process information to those families. And we discuss the transition from kindergarten, from early intervention to kindergarten with families. So parents and advocates can find our contact information in various locations, most notably on the first page of the procedural safeguard notice. As I mentioned, there are 3 Consult Line specialists available to assist parents and advocates. We can be reached by phone, email, contact form, or through the live chat feature on our website. When calling by phone, a message will prompt you to leave your name, phone number, preferred contact hours, any brief description of the reason for your call. Specialists are available from 8 a.m. to 4 p.m., Monday through Friday, to accommodate callers. We return the calls in the order that they're received, and we will make several attempts to reach each caller, normally 3 times over 3 business days. For those who speak another language other than English, we use language line interpreters to ensure effective communication. So Consult Line receives a variety of calls at the Consult Line for many reasons. Common inquiries can include IEP compliance, understanding rights within special education, clarifying the evaluation process, addressing disagreements with schools, requesting resources, and occasionally those questions about early intervention. In our voicemail message, we direct callers with those questions about early intervention services to contact OCTEL, but sometimes they still make it through. Consult Line staff can assist with inquiries regarding the transition from early intervention to kindergarten, as well as, again, those questions about due process, facilitation, and mediation. But for identification services and evaluations, we'll refer those families over to OCTEL for early intervention. But other than that, the types of calls that we can respond to are, those disagreements, bullying, clarification of the regulations, Section 504. We also cover Chapter 16 of Gifted. So a wide breadth of special education related topics. Does anyone have any questions about Consult Line before we get into the call resolution process?
Can you, I have a quick question. So, I mean, I've called the Consult Line numerous times, like in many years, but I think people sometimes, it's not like you're going to report back to the school or say anything if someone's calling the Consult Line with questions. I just think sometimes people they're not sure how it's completely independent. It's not something that, you know what I mean? So I just wanted to clarify that for folks that you guys are so helpful, and any kind of question you have, like if you're not sure, call, because they will give you some sort of guidance, and it's not like,
Oh, absolutely. We don't think
not like you're doing something you shouldn't be. Because a lot of people, I have to say this, like a lot of folks that call in for advocacy, they think the school is like the authority, and the school said we have to do this. And they don't realize that there's options. So I always just tell people there's a lot of options out there. And one is just to get more educated on if you have a question. And that's why the Consult Line is such a valuable resource. So anyway, just throwing that out there.
Yeah, thank you. A very important point. Need to add that to the presentation for sure. Yes, we do not have any contact with LEAs. Our conversations are confidential. They don't leave the Consult Line. Even if you do go ahead and file the mediation or due process, our systems don't intermingle. Everything that you say on Consult Line is confidential unless, there's a clear threat or something. But that's another circumstance. But yeah, so I think Consult Line is a really great resource. Obviously, I'm a little biased because I work there, but we take impartiality and neutrality very seriously. That's why we're actually not able to intermingle with other organizations. I use certain school districts because it creates a conflict of interest. So I actually haven't joined the local task force in my area because I am afraid that it would be a conflict of interest. I reside in Pike County, so I'm in your area, but you likely haven't seen me at any meetings or anything because I take my Consult Line position very seriously that I need to remain neutral and impartial. And if people have questions, they can call Consult Line. Any other questions before we move on? Conversations with During conversations with parents, a specialist can identify a potential compliance related issue. To address those concerns proactively, the call resolution process was developed to resolve those compliance issues before they escalate into formal complaints. So this is something specific that ODR can do where we analyze the conversation to determine if the call resolution process is a suitable option. So it's sort of a quicker state complaint. Before offering the call resolution process to the parent, we have to ensure that all aspects are covered by providing information about those state and federal requirements related to the issue, discussing those different options for local resolution, and explaining the state complaint process and assessing whether the issue meets the criteria for the call resolution process. With the parent's permission, we may offer to send a courtesy email to your director of special education at the school. But again, that's with the parent's permission, outlining your concern and the proposed resolution. It also involves the Bureau for Special Education's regional compliance advisor and the division chief of the Bureau for Special Education, as they're also copied on that email, outlining your concerns and the proposed resolution. Once the email has been sent to the school, our role is complete. We are no longer involved from that moment. From that point on, it's up to the school to manage the information as they see fit and to determine if any action is warranted. The Bureau for Special Education advisor will also follow up with the LEA, and the parent is informed that the LEA and or BSC advisor may contact them. It's important to note that the call resolution process does not apply to early intervention for children aged birth to 5. Complaints and concerns regarding early intervention are referred to OCTEL, which they have their own process in place for resolving those early dispute issues. Does anyone have any questions about the CRP? Okay, so here are a few examples of situations which we could offer a call resolution process. Issues related to IEP implementation, timeline violations, like for an evaluation going over 60 days, violations of discipline rules, like that manifestation determination, a child being out of school, lack of notice being provided to the parent, a lack of consent, a parent not being informed of their child's progress, or instances where a behavior plan is not being followed. Callers are not required to disclose their locations, but in some cases, you can decide to. It's totally up to you. Calls are distributed across the Commonwealth, and this chart illustrates a representative distribution of those calls. This data is also available in our annual report, which can be found on the ODR website. So obviously, we get more calls from the Philadelphia, Pittsburgh area, that capital area, intermediate unit, Montgomery County, those areas. Actually, the distribution of calls in the Northeast always surprises me, because we don't hear from y'all very much. I hope it's because everything is going well, but I know that's not always the case. So I'm hoping we can get more information out there so all of y'all feel more comfortable to give us a call. We'll now move on to discussing our family engagement services. We offer fantastic resources for parents preparing to participate in mediation or represent themselves in a due process hearing. For instance, we provide a guide to special education hearings that parents can utilize. Additionally, we're available to answer those procedural questions to help parents understand the mechanics of mediation and due process hearings. Our approach to serving parents is grounded in effective family engagement practices, and it's important to note that specialists, again, do not provide advocacy or legal advice. But we can advise you on the procedures, the timelines for mediation, due process, all of that. Any questions so far? If not, we'll move on to IEP, IFSP facilitation. All right, great. So IEP and IFSP facilitation, these are not mandated, and it's not intended to be used for every IEP or IFSP meeting. It is available for those situations where both parties agree that the presence of a neutral and impartial third party could help to address issues that can hinder the completion of an agreed upon IEP or IFSP. An IFSP, or the Individualized Family Service Plan, is a written document similar to an IEP for
There
children
were
who are
some things
receiving.
already scheduled. Sorry.
Sorry? Oh, it's okay. It's similar to an IEP for those children receiving those early intervention services for the Birth to 3 program. Facilitation can be initiated by either party. So that means schools can also request a facilitator be present, but the parent has to provide that consent as well. The facilitators are provided by the Office for Dispute Resolution, again, neutral and impartial, and have completed the necessary training requirements. Again, it's voluntary, meaning both parties must agree to the presence and assistance of a neutral facilitator when discussing an IEP or IFSP matter. Facilitation is typically used when communication between the parent and the LEA has become strained or stalled. The facilitator can help to foster an atmosphere of fairness and support the successful drafting of an IEP or IFSP. What's also great is there's no cost for IDEA related claims, and parents can contact ConsultLine for information and assistance as needed. So we can provide you information about IFSP or IEP meeting facilitation, as well as the form to request it. They're also available on our website. It's important to note that the regulations state that the school is responsible for scheduling and conducting the IEP or IFSP meeting with the parent. IEP or IFSP facilitation does not change that requirement. The school, not ODR, sets that date. They're also responsible for still inviting the parent and leading the meeting as usual. ODR will send a facilitator only after the LEA has established the date, time, and location for the meeting, and when both parties have agreed to use a facilitator. And again, the facilitator is not a member of the IEP or IFSP team. The team remains the decision makers, with the facilitator acting as a guest. Usually I explain it as being a referee. If the game is going well or the meeting is going well and there isn't much need for interference, then the IEP facilitator kind of just sits back. But if there's one party that's speaking more than the other, or if one was getting bombarded, that is when they'll step in or do a little bit of conflict resolution along the way if it's becoming strained or stalled. The facilitator will prepare for the IEP or IFSP meeting by contacting both the parent and the LEA rep. During this preparation, they will discuss the purpose of facilitation and answer any questions about the process. The facilitator will also take the time to understand the concerns and issues that are relevant to the meeting. And again, their role is to enhance communication, helping both sides to address disagreements or conflicts related to the IEP or IFSP in a productive manner. Again, the role of the facilitator is not to provide technical assistance or input regarding the content of the IEP or IFSP. Even if you call ConsultLine or do a facilitation or a mediation, their role is not to provide information about the content of a student's IEP. Instead, we offer support in terms of the process, communication, effectiveness, and efficiency of your meeting. A helpful analogy for understanding the role of the facilitator is, again, the referee. At times, they have to get more involved to ensure fair play and keep the meeting going. There are several benefits to considering IEP or IFSP facilitation. The process can enhance communication and positively impact the relationship between the school and the family. It provides expertise in communication and conflict resolution strategies, helping participants explore their concerns, identify options, and resolve disagreements before they escalate to a more formal dispute resolution option, like a due process hearing. Are there any questions about IEP facilitation?
Yeah, I have a question. So
Yeah.
do you guys have any information like after the fact, like how effective is IEP facilitation? Like, do you ever get information on the outcomes? Like, did it prevent people from going to due process by having this IEP facilitation? Did both sides feel that like it was effective?
Great
And
question. Yeah, so we do an evaluation for every IEP facilitation, mediation, due process. ConsultLine reaches out to those families after they've utilized our services, and families can choose whether or not they provide feedback. In terms of hard statistics, I don't think that's in the annual report. But it would be interesting to think about. I would say the feedback that we get is very mixed. Because I mean, just going to facilitation does not necessarily mean that there's still that it's going to magically resolve all of the problems. We acknowledge that. But in some cases, it can be useful to have a neutral and impartial person just present at the meeting. I know parents want advocates a lot because they feel that having someone who has knowledge but also is not on the opposing team, so to speak, can be valuable to have in that meeting. They look at it as someone who can hold the school accountable, even though that's not the role of ODR either, but nevertheless, it can be valuable nevertheless to have someone in the meeting who can help with that effective communication and things like that. So I will see. I know we talk in the annual report a lot about the rates of mediation and due process, but not necessarily do we provide specific comments from people's feedback. Again, we try to keep it pretty confidential when they do reach back out to us
Now,
to
when does
provide.
the annual report come out? Like, is that like a fiscal year thing or after the regular calendar year or?
Our new annual report for last year is available on our website now,
Oh,
and
okay,
that data is integrated into this presentation, thankfully, as well.
nice.
Yeah.
I was just curious because I hear like, I just anecdotally like hear like more districts saying like, oh, why don't parents ask for this IEP facilitation or even mediation? Like we would be willing to do that. So
That's interesting.
yeah, I'm wondering if
I mean,
the,
districts can request it too, but whether or not
right,
they, well, I
yeah,
would say we get a lot more parent requests than we ever do
yeah, that's
LEA.
what I was curious to see. Like, when I hear people say that, I'm like, oh,
Yeah.
So, yeah, so as I've never gone to an IEP facilitation yet, but I've gone to a couple media, I mean, I've been to mediation before with clients, but, um, I suggest it to people all the time, because if you have a neutral party there, like you said, the referee, like if your IEP's meeting's lasting like 3 hours and you're still on the same topic and you can't get past that because of personalities or whatever, then that's probably a good idea to have the facilitator to keep things going, right? Like,
Absolutely. Yeah. Like I said, like the role of ODR, people think that we can hold them accountable or like keep them compliant.
yeah,
Unfortunately, that is not our role. We are not in enforcement, but nevertheless, like I said, having a neutral and impartial third party there to help keep things moving, or just point out the issues, especially because there's somebody sitting on the sideline to say, okay, I think based on what each party has said, these are the main roadblocks to coming to an agreement.
right,
Really
yeah,
just lay it all out on the table, right?
I think it would be very helpful. Okay,
Yeah,
thank you.
of course. Jenna, you had your hand raised.
Yes, thank you very much for the acknowledgement. So far, so good. Thank you for all this wonderful information. I'm wondering if it is a fair statement based on what you've provided so far that really one should start with a consult, say with the ARC or some other advocate prior to reaching out to ODR. Is that a fair statement?
Um, I mean, overall, parents have all of the power in this, right? So, like, you don't necessarily have to follow a certain process to, try a facilitation, then talk to an advocate, or talk to an advocate, then follow mediation. You can skip right to due process if you want to. Um, but we typically do encourage the more cordial and informal options like trying a facilitation. Or yeah, if you want to reach out to an advocate, that's certainly something that you can try as well. The way that I usually distinguish a facilitator from consult line and even an advocate is that consult line can answer your questions about regulations and what your options are, right? Whereas an advocate can provide more personalized support. They can review your student's IEP. They can review a reevaluation report. They can go to a meeting with you. Whereas a facilitator, again, their role is really just to be very neutral, very impartial, but they can kind of act as this person that can sit on the sidelines and say, okay, well, this is what I'm observing. How can we move forward from this? What are areas that you all do agree upon at this point? You know, and then kind of be that person who simmers down those meetings that can get particularly contentious or conflicted. That's how I would delineate each option. At Consult Line, I'm never going to advise a parent to do anything. I'm just going to give you all your options and say, you can do a facilitation if you feel that that's, you know, a natural next step based on your situation and what you feel needs to happen next. Or I'll say, here's the advocate information. You can give the ARC a call, see if, you know, you do want them to review your student's IEP, see if they have any recommendations for you on next steps, or if you do want them to attend a meeting with you. So again, we stay very neutral in that sense. Sometimes people will call and say, I want a due process. I don't want anything else. And I'm like, okay, here's the due process information.
Thank you for the clarification.
Yeah, of course. So moving on to mediation. Mediation is a voluntary process requiring the willingness of both the parent and the school to participate. Otherwise, the mediation session will not occur. If either party declines, no one, including ODR, the Pennsylvania Department of Education, or the opposing side, can compel the other party to participate. In some cases, one party can feel that a fact finder is more necessary rather than a mediator, leading them to decline the mediation. Regardless of any reason that they choose not to participate, we respect their decision of both parents and educators regarding their participation in mediation while encouraging consideration of this highly effective conflict resolution service that we offer. The spirit of mediation is one of collaboration and respect. For mediation to be successful, it's essential that all participants come to the table prepared and willing to discuss the issues that brought them there to begin with. If that willingness is lacking, mediation can be ineffective. When mediation is successful and an agreement is reached, the written agreement is binding in a court of law. It's important to remember that choosing mediation does not waive either party's right to due process. Often mediation is requested simultaneously with due process. So when parents call Consult Line, I'm like, you can do all of these options, you can do none of these options, or you can choose one of them. It's totally up to you. So your right to file due process always remains. Mediation is, it can be scheduled more quickly though. Reaching an agreement in mediation can allow the parties to withdraw their due process request. Mediation is generally less stressful, less expensive, and less time consuming than pursuing due process, making it a valuable alternative to consider before escalating to the level of due process. So as far as the mediation process goes, what can you expect? The mediator will begin with introductions, an orientation, and a review of the relevant paperwork. Next, each side will have uninterrupted time to share their story and explain what brought them to mediation to begin with. After both sides have presented their opening statements and the mediator has asked any necessary clarifying questions, a joint session takes place. While the opening statements are conducted privately, between the mediator and each side, the joint session is where the dialogue occurs between both parties. Initially, there can sometimes be limited communication between the parent and the LEA, but as the joint session progresses, the mediator is going to facilitate discussions to address those issues. At some point, the mediator can request a private meeting known as a caucus with each side to better understand any roadblocks preventing that agreement. It's also possible that either or both parties will request a private caucus. So either party can request or the mediator can request a caucus. And after that caucus, the joint session resumes. It's important to note that the specific needs of each mediation will determine when and if and how often a caucus is utilized. The ultimate goal of mediation is to reach an agreement, and the mediator will work diligently with both parties to assist them in achieving that goal. If an agreement is reached, it'll be documented in writing, and both parties will receive a copy to take with them. Once both parties have indicated their willingness to participate in mediation, the Office for Dispute Resolution, we manage the details, including coordinating the date and time, as well as the location and assigning a mediator, and obtaining the list of participants from each side as well. For IDEA related mediations, there's no cost to either party. In cases involving gifted or Section 504 related issues, if mediation is agreed upon, the LEA will cover the cost of the mediator. ODR does not cover the expenses for any guests invited to participate. So say the parent wants to bring their child's therapist, psychologist, advocate, something, and there are fees associated with that. The Office for Dispute Resolution doesn't cover those. The parent would be responsible for those fees. So these are a list of commonly mediated issues. Any topic under Part B or Part C can be mediated. It includes common topics like placement, least restrictive environment, IEP implementation, related services, levels of service, extended school year, evaluations, functional behavior assessments, transition planning, accommodations, a whole slew of things, really. So the participants in mediation, let's discuss who can attend mediation. While the regulations do not specify the number of participants allowed on either side, the Office for Dispute Resolution recommends having 3 participants from each party, though they can agree to a different arrangement if they want. For the family, you can bring anyone who has knowledge of your child's disability. Again, it could be an advocate, a therapist, even a family member or friend who understands the issues and can support the parent. The school will select their participants, one of whom must have the authority to commit resources, meaning they have to be able to make decisions on behalf of the LEA. So there's none of this, oh, we need to talk to XYZ person before we can make a decision. No, somebody that can make a decision needs to be in that room. Parents also have the option of bringing an attorney. However, if you decide to bring an attorney as a parent, the LEA may also bring an attorney if the parent brings an attorney. If you don't bring an attorney, the school may not bring their attorney. So this chart illustrates all of the mediation requests broken down by intermediate unit. It's important to note that not all requests proceed to a mediation session, approximately half do. There are several reasons why some requests may not culminate in a mediation session, like either party can choose not to participate since mediation is voluntary, either side can withdraw the request after the session has been scheduled, or conciliation may occur, meaning the parties reached an agreement on their own before the mediation took place. Pennsylvania's mediation agreement rate meets the standards set by OSEP. For a 5-year retrospective mediation case requests, that's in our annual report. Go ahead, Jenna.
Hello, thank you. Appreciate it. Just want to jump back to the previous slide. Does the LEA need to notify the parent that they will have their district attorney on site, and the opposite? Does the parent need to notify the school, and in particular the LEA, that they are bringing an attorney?
So if the parent chooses to bring an attorney, you would list that on your mediation request. There's communication still happening even while the mediation is being scheduled. So the role of the mediation case manager is to reach out, get, additional information. There's a parent information form. There is your schedule, when you're available over the next couple weeks. And then also the expectations of mediation participants
Oh,
forms that
okay.
you sign. So if you were bringing an attorney, you would list that on your mediation request, and then in which case the school would then also notify ODR that, as well as the parent, that their attorney was also intending to come.
I see. Okay. So have you ever found a case where a parent a parent did not have representation, but the school district did bring an attorney?
If they did, that would be a procedural violation.
I
So
see.
you could do a CRP or a state complaint.
Thank you.
Certainly. Any other questions?
No, thank you. I'm trying to hit the mute button. Thanks.
Shannon, I would just comment, if it's okay, that, you can bring anybody that knows about your child, and they can offer information to that meeting. So you could bring an advocate, or, behavior specialist, or a case manager, or whoever, as well.
Thank you.
Absolutely. Wonderful. Okay, so there are several types of mediation offered by the Office for Dispute Resolution, including evaluative mediation. So I find this is really cool, actually. This evaluative mediation is like facilitative mediation with a reality check. In evaluative mediation, the mediator is neutral still, but they are still an expert in special education who can leverage their educational and legal knowledge and explore potential outcomes with the parties, ultimately aiming to facilitate a collaborative agreement. So what that means is they can utilize the same techniques as a facilitative mediator, like the opening statement, caucuses, questioning, brainstorming. When the parties can become off track or stuck on a particular issue, the mediator can intervene with directive questions and offer feedback and suggestions for consideration. They can also discuss potential outcomes and consider what a hearing officer might be likely to decide. While we can't predict what a hearing officer can decide, they can examine from various angles and help parties create a more informed, party drafted mediation agreement. Um, so it's basically taking their knowledge of special education law and hearing officer decisions to help weigh in about the agreement between the parties to say, okay, well, I understand the parent wants this placement, but the law favors least restrictive environments. So the hearing officer might say XYZ because the law favors least restrictive environment, and this student may not be in the least restrictive environment if the parent places, chooses that particular placement. Just something like that as an example. But it's really interesting that they can provide that kind of feedback and consider what a hearing officer might be likely to decide. Currently, we have 2 evaluative mediators. All evaluative mediations are conducted virtually. For more information, you can view those biographies on the ODR website. Once the parties request mediation, you can just inform our mediation case manager if you would like an evaluative mediation in particular, and she'll arrange that. Any questions? Oh, yes, I see we are running a bit over time. Is that okay?
Oh, yeah, you're fine. We're
Okay.
usually done about 11:30, so we have time.
Okay. All right. So the IDEA mandates that mediation has to be impartial, conducted by individuals trained in effective mediation techniques and knowledgeable about the laws and regulations governing the provision of special education and related services. The independent contractors for ODR come from a diverse range of backgrounds, including mediators, attorneys, consultants, former educators, therapists, and professors of special education from colleges and universities. The mediators serve as neutral third parties. Again, they are not employees of the agency involved in the child's education and do not have any personal or professional conflicts of interest. Mediators are assigned to cases on a rotational basis. Any other questions about mediation before we move on to due process? Wonderful. All right. A due process hearing can be requested for disputes related to identification, evaluation, placement, or the provision of a free and appropriate public education or FAPE. A due process hearing is similar to a trial or a court case, with the hearing officer presiding and acting as a judge. These hearings may take place over a single session or sometimes multiple sessions. The local education agency is always represented by an attorney in a due process, while a parent may choose to hire an attorney or represent themselves, a process known as pro se. During the hearing, witnesses can be questioned and cross-examined, and evidence is presented. At the conclusion of the hearing officer will issue a written decision. Most due process requests received by ODR are initiated by parents. However, either the parent or the LEA can request due process. This option is available for families of children who are or are suspected to be individuals with disabilities. It also extends to gifted students and children with Chapter 15/Section 504 service agreements. The most common cases involve issues related to compensatory education, IEP disputes, placement, and evaluation. When a case is fully adjudicated, it means that both parties have presented their respective arguments and the hearing officer issues a written decision. The decision is based on the evidence presented, fact finding, the credibility of witnesses, and legal conclusions determined throughout the hearing session or sessions. Hearing officers are also impartial and proficient in special education law. They They possess the necessary knowledge and skills to conduct hearings and write decisions in accordance with standard legal practices. To ensure impartiality as required by IDEA, hearing officers have complete autonomy in administering due process hearings and rendering decisions. ODR maintains no direct oversight and exerts no influence over how hearing officers manage the cases assigned to them. Furthermore, the Office for Dispute Resolution does not determine whether an LEA is in compliance with the hearing officer's decision, nor does ODR interpret these decisions. So sometimes on Consult Line, parents will call wanting Consult Line to interpret the hearing officer's decision, especially if they were a pro se parent, but we are not able to do so. Sometimes they also call with those compliance related issues, which we are also not able to do. Hearing officers, all hearing officers are attorneys with 5 employed full-time at the Office for Dispute Resolution. Additionally, there is an independent contractor available to oversee overflow cases and gifted education matters. All of their bios are on our website. Hearing officer decisions are grounded in evidence, findings of fact, credibility determinations, and legal conclusions. These decisions are available on the ODR website. We actually have a really good searchable database where you can search by school district, you can search by keyword, any measure of the decision, which is pretty cool. You can also join our listserv to receive notifications when new decisions are posted. For more information, you can visit our website, www.odr-pa.org. This chart represents due process requests categorized by intermediate unit. So it's interesting to me that IU-19 is very high. So we compare with the Philadelphia, Montgomery County intermediate unit area. I often speculate to myself about why that could be. Maybe families don't know about our other resolution options. Maybe they don't know that they can call Consult Line and ask about facilitation or mediation. Or maybe they're just at the end of the rope and they want due process instead. But nevertheless, that's why the Office for Dispute Resolution is here. That's why Consult Line exists, so that we can talk through all the options and help to assist those pro se parents, those who represent themselves in a due process.
I would comment on that as well too, because if you look at the mediation numbers in IU-19 are very low, but the people who are going right to due process, do they understand that they have other options? Probably not. Or they want the quickest resolution, maybe.
Due process is not one of the quickest, though.
No, but a quickest resolution meaning I said that wrong. Meaning that you could call a lawyer and they're going to go to due process, or they're going to take care of for you versus you. You know what I mean?
That's true.
Taking more of the lead. That would be possible. But I think there's definitely a lot of room for people to start learning more in our area and looking at other options besides due process. I also thought it's interesting that there's one area, and I guess, that has no requests at all, which also seems a little odd. And even if it's a rural area and it's maybe not a lot of folks, I would think they'd at least have a couple.
Right. Yeah. I look at the trends too, and I find it really interesting. So that's why we just continue our outreach efforts, to make people aware of ODR and how we can try to support them.
Yes, great. Thank you.
Absolutely. So to ensure that parties have every opportunity to reach an agreement before a due process hearing is held, IDEA mandates that when a parent requests a due process, the local education agency must hold a resolution meeting with the parent within 15 days of the request, unless both parties agree to waive the resolution meeting in writing. The parent and the LEA may choose to waive the meeting or may opt to use mediation instead. ODR tracks data related to those resolution meetings, and we report the gathered information to the Bureau for Special Education and OCDEL for those early intervention cases. So an example of the data that we would collect is like, okay, how many parties resolve the issues in a resolution meeting rather than going to a due process? How many families or parties decide to utilize a resolution meeting facilitator? That's also a service that we offer, is resolution meeting facilitation. That's actually in our next slide. Yeah, so that's just an example. So resolution meeting facilitation is available for any parent-initiated due process request involving a child with a disability. This process is voluntary and free of charge for both parents and the school. Once the LEA and parents schedule the meeting and agree to utilize a facilitator by submitting our request form, ODR will arrange for a facilitator to assist in the resolution meeting. If the facilitation leads to an agreement and resolves all the issues, the parent can request the hearing officer to withdraw their due process request. The facilitation not only helps to build and strengthen relationships, but also provides an opportunity for parties to resolve conflicts collaboratively, potentially avoiding the need for a due process hearing. By using resolution meeting facilitation, families and school professionals can explore new options for the child in a less stressful environment compared to the traditional due process hearings. So the role of the facilitator in a resolution meeting would be to assist the parties in focusing on the child's needs, maintaining open lines of communication, clarifying points of agreement and disagreement, remaining impartial throughout the process. The facilitator does not make decisions for the group. If requested, the facilitator can also help the parties draft an agreement to ensure that all of their concerns are clearly documented. But again, the role of the facilitator is not to decide the outcome. If it goes to a due process hearing, then the hearing officer decides, but the facilitator is strictly there to help with the communication piece, not to decide. So this chart compares due process hearings and mediation, highlighting some advantages of resolving disputes through mediation. Feel free to read over all those details and then you can ask me any questions if you'd like.
I have a quick question going back to the resolution mediator. So is the
Yeah.
resolution mediation or mediator, is that only if you're going to due process and then you come up with the resolution ahead of time? Or is that like, if you're not going to due process and you just want to try to put a resolution together for a situation? Is that
Great
making sense?
question. Yeah, so the resolution meeting facilitation would be for someone who has an established due process hearing complaint, and it's for IDEA cases only, so it wouldn't apply to Section 504 or gifted. But in the resolution meeting, you can request a facilitator. Without a facilitator, if you go to a resolution meeting and you're a pro se parent, you're on your own. It's you on your side and then the school on their side, and their attorney can participate if you have an attorney. But so the same rules apply. If the parent does not bring an attorney to the resolution meeting, the school may not bring an attorney to the resolution meeting. Or if the parent does have an attorney, the school district's attorney may participate in the resolution meeting. So I would say, I mean, you can request a facilitator whether you have an attorney or not. But it might be helpful for a pro se parent to request a facilitator for the resolution meeting, especially if they hope to not have to go to the hearing. If there's any way that they think that they could overcome the roadblocks and come to an agreement in the resolution meeting, by all means, great. When parents call consult line and we talk about due process, I talk a lot about the burden of proof. If you read the hearing officer decisions, it talks a lot about the parent's burden of proof, having the evidence that supports, why you want to switch your child's placement, why were they denied a free and appropriate public education, why you feel that the evidence supports that your child is a child with a disability. Having all of that documentation, all of that evidence organized into the exhibits and things like that can be a bit overwhelming. Admittedly, the parent guide that we have about due process is approximately 126 pages. So it can be a little overwhelming. So we talk about resolution meeting facilitation as just one more way to help a parent feel a little bit more supported and try to help facilitate some sort of agreement, especially before it goes to a due process hearing.
Thank you.
Yeah, so we also tell parents that if you go to due process and you might not have all of the evidence that you need, or when the hearing officer considers the evidence and the witness testimony and all of that, it's possible that they could come to a decision that no one is happy with, which is obviously not ideal. but it can happen. We always say that the best resolutions are ones that are drafted by parent and school together because it's agreed upon. Any other questions on that?
I think it's good that you could go to mediation. It's not preventing you from going to due process if it doesn't work out. So why not give it a shot? Maybe. I
Absolutely.
don't know.
Yeah. Yeah. And I mean, when I talk to parents on Consult Line about mediation, I'm like, the coolest part about it is that you and the school can come to any solution that you feel is appropriate. Even if that's not what the hearing officer would decide based upon the evidence that you have, as long as you and the school agree upon it, that's great. That's what you can do moving forward. And I always tell parents to ask for anything under the sun. And then if you feel like there's just this fundamental disagreement, but you really feel that that's what's best for your child, then you can utilize mediation, you can utilize IEP facilitation, and see if you might be able to come to an agreement. It might not be exactly what you had imagined, but if you're able to negotiate, collaborate, that's one of the best things about mediation is that it's collaborative. Any kind of issue can be addressed. You and the school together decide what information is important to discuss, and it's free. All right. Any other questions? I think we're almost done. Oh yeah, a couple more slides. That's all we got. So the hearing officer settlement conference is another opportunity for parties who are close to a resolution but have identifiable sticking points or roadblocks. It's another opportunity for them to work with a sitting hearing officer to see if their issues can be overcome. The goal is to encourage dialogue and negotiation between the parent and the LEA before a due process hearing takes place. This can also be requested without an active due process hearing. So during a HOSC, a hearing officer settlement conference, a hearing officer acts as a neutral facilitator to help both sides discuss their perspectives, clarify issues, and explore potential resolutions. The process is confidential, meaning that anything discussed cannot be used in a subsequent hearing if an agreement isn't reached. The same goes for a mediation. So mediation is confidential and it's voluntary, and so is a hearing officer settlement conference, confidential and voluntary. The hearing officer settlement conference can be beneficial because they provide a chance to resolve disputes without the formalities and stress of a hearing. The due process hearing remains scheduled unless the parties tell the due process hearing officer that the case has been settled and the hearing is no longer needed. But again, this can be requested without an active due process. So a settlement hearing officer is a qualified Office for Dispute Resolution hearing officer, and they bring valuable knowledge and experience in handling these special education disputes. They can provide insights to both parents and schools regarding the issues that they have and obstacles that can be hindering their settlement. The process is conducted via telephone, making it convenient to schedule and ensuring complete confidentiality. Importantly, the due process hearing officer assigned to the case will not be informed of any discussions that take place during the hearing officer settlement conference. So if you have an active due process, you have a hearing officer assigned, and you decide to try the hearing officer settlement conference, it's actually a different hearing officer who will sit in your hearing officer settlement conference. Again, participation in the settlement conference is entirely voluntary. Both parties must agree to engage in the process, and neither will ever be compelled to participate. Its collaborative approach aims to facilitate resolution while prioritizing the needs and interests of the student. Does anyone have any questions about the hearing officer settlement conference? All right, great. So that actually concludes our overview of the Office for Dispute Resolution Services. I'd like to share an additional learning opportunity in case anyone here has not done it. Our training on conflict resolution skills for schools and families. It's sponsored by the Office for Dispute Resolution and presented by the Cora Good Shepherd Mediation. These sessions are typically offered every other month, and you can register on the Patent website by clicking on the calendar link and searching for the session. If you'd like more information about this training, you can email me or connect with me after the session. Actually, it's really great. The training will focus on equipping participants with the skills needed to effectively resolve conflicts and enhance communication throughout a child's educational journey. It will cover key topics such as an introduction to conflict resolution, conflict management styles and self-assessment, communication skills, perceptions and attitudes, and a 6-step conflict resolution process. So it's actually really similar to the mediation training that Cora Good Shepherd provides. I'll leave you with one last thought. The strength of a relationship is not to be measured in the frequency or the magnitude of the difficulties encountered, but rather in the ability to resolve them. It's an insightful quote by Nicholas Martin, which encourages us to reflect on the nature of conflict and dispute resolution. At ODR, we remain committed to finding and providing opportunities for families and schools to collaborate effectively, always with the best interests of the child or the student at heart. And then if you have any other further questions or would like to, schedule another session with us, say for one of the other task force or your organization, because I know there were other organizations present, please don't hesitate to reach out to us. And again, thank you for the opportunity to present this information to you today.
Thank you so much. I'm going to stop the recording, and then that way, if anybody has any questions or anything they want to talk about.
Great, thank you.